Good afternoon, ladies and gentlemen. My name is Virginia Comolli. I'm the research fellow running the Security and Development Program here at IISS. Thank you for joining us today for a discussion on ending sexual violence in conflict. I'm very pleased to see lots of old friends and also new faces. For those of you who are not very familiar with IISS, we are a think tank focusing primarily on security and defense issues. This is our headquarters. We also have international offices in Washington, in Singapore, in Bahrain, and a satellite office in Delhi, in India. Over the years, we have expanded our research portfolio quite considerably, including with the creation of the program I currently run, Security and Development, that really aims at combining security and defense aspect with humanitarian and developmental issues in our study of conflict. We very much welcome external input, and I would very much encourage you to join our intellectual community. So please, if you have any suggestions, ideas, please come and talk to us or talk to me at the end of the event or drop us a line. We are also a membership organization, so if you would like to hear more about our events, publications and activities more broadly, also ask me at the end, or we also have some written material in the stand just outside the door. Today is a sad day. In fact, coincidentally, this event falls on the one-year anniversary of the abduction of over 200 schoolgirls in northern Nigeria. As some of you may know, this is an issue particularly close to my heart, but more importantly, is a sharp reminder that women and young girls are often they suffer disproportionately as a result of conflict, and indeed are targeted exactly because they are women. Regrettably, the Chibok girls don't represent an isolated case of women forced into marriage or sexual servitude. Sexual violence enabled by a widespread culture of impunity remains a feature of many conflicts around the world. But today we are not here just to describe the problem. We are very fortunate to welcome Professor Kristen Chinkin, Director of the recently established Centre on Women, Peace and Security at the London School of Economics, who will take us through what needs to be done to bring to an end this terrible form of violence. Professor Chinkin is Professor of International Law, a barrister, and also winner of the prestigious American Society of International Law 2005 Goller-Butcher Medal for outstanding contributions to the development or effective realization of international human rights law. Professor Chinkin has devoted a large part of her career to changing the way governments work to protect women's rights, and I'm grateful to her for taking the time to join us today. So thank you so much. Professor Chinkin will speak on the record for about 30 minutes, is that right?
Yeah.
And we'll then have plenty of time for discussion. So, Professor Chinkin, the floor is yours.
Thank you, Virginia, and thank you for the invitation to come today. I'm not so sure that I'm going to be talking about what we can do about the issues of sexual violence. I think the impetus for the invitation was the creation of the new centre at the London School of Economics on women, peace and security. So rather to talk a bit about what we hope for the centre and the legal framework that supports the work on women, peace and security. It's always difficult. Great to be here. I'm also very impressed so many of you have given up a beautiful lunchtime to come and sit inside and talk about these sort of grim issues. But I think it's also important that from the outset we're thinking about sort of what are the legal underpinnings that support the centre and possible lines of future behaviour and so on. So what I'll do is just very briefly outline the sort of origins of the centre, talk about the legal frameworks that are sustaining it. I lost my line of thought on that as well. I have no idea how much all of you know. I suspect there are a lot of people in the room who will know more about the various legal frameworks, certainly than I'm going to be able to say in half an hour, possibly more than I know about them. So if it is rather too basic for some people, I apologise. If for other people who don't know so much about it, I lose you in legal technicalities, please ask me afterwards and raise that. As I say, it's always difficult to know exactly where to place this sort of talk. Okay, now the Centre for Women, Peace and Security was launched in February of this year. We're very much still at the planning stage and deciding where it is going to go in various ways. But it essentially has arisen out of two separate traditions or sets of initiatives, I suppose. The first, which I'm sure you are all familiar with, is the Prevention of Sexual Violence and Armed Conflict Initiative of William Hague, that William Hague set up in conjunction with the Special Envoy of UNHCR, Angelina Jolie, 2 years ago now, nearly 3 years ago now, in May 2012. One of the sort of significant events of the PSVI initiative was the Global Summit that was held in London last summer. The focus of that initiative is essentially prevention of and trying to enhance accountability for sexual violence committed in armed conflict, ending impunity. I mean, that is sort of the short message around the initiative. The Global Summit was probably the sort of high spot in terms of public awareness, so on. But there are also multiple other aspects relating to the initiative. For instance, there was the Declaration of Commitment to End Sexual Violence and Conflict, which was a declaration first sponsored before the G8. Then it has been incorporated into Security Council resolutions. It's now been adopted by over 100 countries. There's deployment of expert teams to areas of conflict. So experts in different fields, lawyers, medical experts, forensic experts, others who in various ways contribute to ending impunity in areas of conflict, training, obviously, and the International Protocol on the Documentation and Investigation of Sexual Violence and Conflict that was launched at the summit meeting in July, and is now again being rolled out in different areas. So that's the sort of PSVI aspect of it. The second is the Women, Peace and Security agenda of the UN Security Council. Again, I'm sure many of you are aware of the celebrations, or I'm not sure about celebrations, what's the word? Reappraisal and thinking about the consequences 15 years later. This is the 15th anniversary of the adoption by the Security Council in 2000 of the groundbreaking resolution 1325 on women, peace and security. There's a major initiative going on at the moment within the UN on reappraising 1325, sort of deciding what's worked, what hasn't, where it's going, etc. I think what's especially important about the Women, Peace and Security agenda that should be emphasised is that this, of course, brings in the issues relating to sexual violence and other harms against women into the Security Council's overall security agenda relating to its primary responsibility for the international peace and security. So it's linking it into a completely different agenda. I think it's also worth noting that PSVI is both narrower and wider than Women, Peace and Security. PSVI is narrower than Women and Peace and Security because of its particular focus only on sexual violence. Other aspects have come in discussion, but it's essentially about prevention of sexual violence. Women, Peace and Security, as I'll talk later, has a much broader agenda than just prevention of sexual violence. Having said that, PSVI is gender neutral, so that it's about prevention of sexual violence against anybody, including men and boys. And one of the big issues, of course, is the still very explored issue about sexual violence against men and boys in conflict. So it is wider in that sense, narrower in the focus on sexual violence. Women, Peace and Security is gender specific, women, peace and security. But I'm also very firmly of the opinion that you can't talk about women, peace and security without exploring gender relations more generally, in particular notions of masculinities and how constructions of masculinity and femininity feed into and obviously have implications for a women, peace and security agenda. So, okay, both initiatives come out of a recognition that conflict, armed conflict, is gendered. so that women and men experience conflict differently because of their gender. And at its most basic level, of course, men are targeted, men are killed in greater numbers than women because they are perceived as fighting forces or as potential fighting forces. Think Srebrenica, where essentially men and women were separated. The men were subject to massacre, mass killings, essentially around the fact that they were perceived as either the current fighting forces or potential fighting forces. The focus that has become on harms committed, gendered harms that are committed to women in armed conflict, has become sexual violence. Having said that, of course, sexual violence is only one form of harm that occurs to women in armed conflict. Many other situations relating, for example, to disappearance of male partners, fathers, family members, etc., relating to loss of land, loss of documentation, a whole host of issues that have gendered implications that are not necessarily resting in sexual violence. Having said that, sexual violence has certainly become the focus of legal responses to harms committed to women, against women in armed conflict, and obviously the focus of the PSVI initiative. Okay, so the concept of conflict as being gendered and the realisation, of course, of the very high incidence of sexual violence against men and women, and we ought to add in as well also targeted sexual violence against those who are identified by their sexual or gender identity, so homosexuality, transgender, etc. So gender as a broad sort of concept. But the focus, obviously, of the Women, Peace and Security Programme is women, sort of within that. But I think that there's a sort of another preliminary point that should be made, which is that we tend to think of sexual violence as in some way essentialising, that we sort of think of common patterns of sexual violence. And I think one of the areas that needs further research, but is also becoming very evident through existing research, is that there is no such common pattern of sexual violence. I mean, perhaps the commonality is its extreme cruelty, its extreme violent nature, and the humiliation and pain and suffering that's associated with it. But beyond that, there are many different patterns of sexual violence, and I'm sure many of you in the room can tell me far more than I know about, but just some sort of examples. Bosnia, the focus tended to be on the detention of women in what became known as rape camps, places where women were detained in, again, what became the accepted language as sex slaves. So essentially being required to cook, clean, etc., and then be available for sexual activity at the whim of those that were detaining them at all times. So sexual slavery type idea. Rwanda, we find sexual violence as an adjunct to, often a precursor to, killing as genocide. And so, again, a rather different pattern. You don't get the detentions in that same way. You get the sexual violence and then either killing or for those that were able to escape. Sierra Leone, we get a pattern of abduction. You just talked about an abduction in Nigeria. I mean, that's another pattern that we see. And the notion then of women who had been abducted becoming wives. So the whole pattern of forced marriages and what flows from forced marriages. Syria, there again, very mixed patterns and different forms and manifestations of sexual violence taking place. So on the one hand, sexual violence in prisons, in detention centres, at checkpoints, in refugee camps where people have fled, and that now, of course, new patterns associated with the advance of ISIS, ISIL, Daesh, whatever one is going to call those forces. So I mean, I think that from the outset it's important not to assume or impose on these sort of patterns of sexual violence a necessary pattern that always flows. that they are context-specific in exactly the same way as conflict is context-specific and has different ways of unfolding. Another perhaps commonality, though, is that there are multiple perpetrators of sexual violence in armed conflict. So we have government forces, security forces, military forces of government, various non-state actors, militia groups, rebel groups, militia groups that really look no more than criminal gangs, quite honestly, but are in various ways involved in the conflict. Members of private military companies, even peacekeepers, as again we are all aware of. So multiple perpetrators, which again, of course, leads to the need for thinking about these problems in different ways. Okay, what are the various legal frameworks that respond to sexual violence in armed conflict, seeing law as one of the instruments, and only one of the instruments, that is available for prevention and combating sexual violence in armed conflict? Now, essentially, until about the early 1990s, really the Bosnian conflicts of 1991, 1992, which is really when legal development began apace and really began moving on. Prior to 1992, there was really very little legal response. The essential legal frameworks were there in the form of the Hague Regulations and Geneva Convention number 4, and I think it's also very clear that the incidence of sexual violence was known about. I mean, it wasn't any surprise to people. But there was essentially silence in terms of responding to such sexual violence through legal mechanisms. So, for example, in war crimes trials, while there may be, and there often were, accounts given of forms of sexual violence in the indictments, in the statements made to the court, they didn't form part of the actual judgment and prosecutions. But since then, so since about 1992, 1993, there have been 4 separate legal regimes that have evolved, and I think one of the big issues is the lack of coherence between these various legal regimes and the need to try and understand better how they can work in conjunction with each other. And I think it's also important that each of these legal regimes has a different objective and a different starting point, so that they are actually focused in different ways. Okay, so the first 2 essentially work together, which is international humanitarian law and international criminal law. International humanitarian law is, of course, the body of law that regulates the means and methods of warfare, the actual conduct of warfare, and identifies who are protected persons in warfare and the degrees of protection that such protected persons can expect. Women, when they are identified through the principle of distinction as civilians, receive the protections under the 4th Geneva Convention relating to civilians, and in particular Article 27 of Geneva 4, which refers to the protection of women against crimes against their honour, including rape, enforced prostitution, and so on. International humanitarian law, of course, is essentially a code of conduct for those who are actually fighting the war. So it's those who are participating at the time. International criminal law has, since really the creation of the ad hoc tribunals for former Yugoslavia and Rwanda, has become the sort of ex post facto of imposing criminal responsibility upon individuals who are convicted of such crimes during warfare. So it is the placing of international humanitarian law into criminal law language, providing for prosecution and, if successful, conviction and punishment. Through a process that really, as I said, began with the adoption of the statute of the ICTY statute in 1993, the beginning of prosecutorial policy in 1995, and then various cases and the adoption of the Rome Statute for the International Criminal Court in 1998, we can now say that in international criminal law, rape and other forms of sexual violence are recognised as a war crime, are recognised as crimes against humanity when the other factors for a crime against humanity are present, are recognised as being potentially genocidal, again when the other factors for identification of genocide are available, are constituent elements of torture as a war crime, as a crime against humanity, as sexual enslavement, equally as war crime, crime against humanity. And I think it's also important to remember that following the Rome Statute, there is now also a crime of gender-based persecution as a crime against humanity. So persecution targeted on the basis of gender as a crime against humanity. That was highly controversial in Rome, in fact, and also very innovative. We could talk all day probably about international criminal law, about its successes and its failures. And just at the most obvious, the number of actual prosecutions that have taken place are still minimal. The development is in legal analysis and in jurisprudence rather than in practical consequences, I would say. The second body of law is human rights law. And human rights law, I think, often gets forgotten in this particular context. But I think it does have an important place for a number of reasons. Again, 1993 was a key moment. In 1993, the Vienna Conference on Human Rights asserted that rape and armed conflict is both a violation of IHL and of human rights law. Now, human rights law, of course, again has a different focus. Human rights law is about state obligations with respect to prevention. And now I think we are at the position where it's accepted as a matter of customary human rights law, as well as in a number of treaties, that states have an obligation to exercise due diligence to prevent, protect, investigate, prosecute and punish offenders, and to pay reparations to victims, understanding reparations in a broad sense, not just financial compensation, but in restorative type sense. The obligations of states with respect to prevention, prosecution, etc., are their obligations with respect to gender-based violence, whether in armed conflict or outside armed conflict. So unlike IHL, we don't need to establish there's an armed conflict before the human rights obligations step in. So importantly, I think 2 points on that. Some of you may be aware of the Istanbul Convention on Preventing and Combating Violence Against Women. It's the Council of Europe's newest human rights convention. And very specifically, it is applicable both in conflict and outside conflict, recognizing that incidents of domestic violence, for example, incidents of forms of violence that are accentuated, exacerbated very frequently by conflict, but which don't fall within the ambit of IHL, still incur state responsibility. For example, because they're committed by partners or whoever from the same side. IHL only encompasses action committed by the so-called enemy, against the other side. Research shows the issues of incidents of gender-based violence against women in conflict not committed by the enemy, and certainly in post-conflict situations. And so the importance of human rights in recognising harms that occur from within a woman's own side, if you like, as well as outside it. Also, human rights law emphasises more clearly than IHL that violence against women, whether in armed conflict or outside armed conflict, is rooted in discrimination. It's rooted in the historic assumption of imbalance in power relations, to use the word of the General Assembly resolution, that therefore combating discrimination against women outside conflict is absolutely core to addressing violence within conflict, and that there is a continuation in notions of such violence. It also requires attention to other human rights issues. So, for example, particularly the importance of access to and delivery of economic and social rights, health issues, for example, as rights entitlement during and after conflict, which may be seen in other areas as sort of services or as add-ons rather than entitlements that are an important part to combating and responding to incidents of sexual violence in armed conflict. And the CEDAW Committee, the Committee on the Elimination of Discrimination Against Women, which is the monitoring body of the Convention on the Elimination of All Forms of Discrimination Against Women, has recently adopted a general recommendation number 30 on the position of women in conflict, post-conflict, and so on, which emphasises very strongly these human rights aspects of prevention of sexual violence in conflict, recognises also that you cannot draw a fine line between conflict and post-conflict. The violence from conflict continues possibly in different ways, but nevertheless manifests itself in so-called post-conflict type situations, and also emphasises again the importance of all the other human rights remaining applicable at that time, not simply a focus on violence. And then the fourth legal agenda is the Women, Peace and Security agenda of the Security Council. And the Women, Peace and Security incorporates the legal regimes that I've just been talking about. So throughout the various Security Council resolutions, you get reference to human rights, you get references to IHL, international criminal law. But nevertheless, the Women, Peace and Security agenda is essentially a political agenda. Political agenda flowing from the Security Council, addressed to member states of the United Nations and to the institutions of the United Nations. Now, it's been 15 years, so there's been now, I can't remember how many resolutions, getting for 8 or 9 resolutions, I think. It's 9, is it now? Right. So thank you. 9 resolutions, and they're all slightly different, and they build upon each other. So there's obviously been an evolution through Women, Peace and Security. But essentially there are 4 pillars relating to Women, Peace and Security. The first is participation. That, of course, is a human rights principle as well, the importance of equality of participation. But the 1325 and successive resolutions have emphasised the participation of women in multiple roles, particularly in all stages of conflict resolution and conflict management, but also in the implementation of peace agreements. Conflict certainly doesn't end with that peace agreement. There is the long stage, subsequently, of implementation, but also in field operations and peace-building missions and peace-keeping missions. So participation across the board. Secondly is integration of a gender perspective into all policies and programmes, including those relating to post-conflict reconstruction. So the importance of examining the ways in which policies and their implementation will impact upon men and women differently, and taking that into account in the design and implementation of such policies. In particular, policies relating to electoral reform, political reform, judicial reform, constitution writing. If post-conflict is seen as sort of a moment for restructuring society, post-conflict reconstruction has become the sort of mantra-type word, peace-building, and as another of the words. The importance of including gender relations and a gender perspective throughout that entire process is an integral part of Women, Peace and Security. Protection that is spelled out in a range of measures, including such things as enforcement of disciplinary measures within military bodies themselves, debunking myths that fuel sexual violence in armed conflict, training, categorical prohibition of all forms of sexual violence against civilians, evacuation programs, vetting armed forces and security forces. So a whole range of different aspects relating to protection. And then the accountability and impunity pillar, the fourth one, through implementation of international criminal law, through transitional justice mechanisms, the beginnings now of a naming and shaming program, the special representative of the Secretary General, which was an institutional response to the issues and incorporated in one of the earlier Women, Peace and Security resolutions. The special representative can now name those that she has found to be implicated in forms of sexual violence. The idea of naming and shaming is of itself intended to have a inhibiting impact, and the possibility even of imposition of Security Council sanctions following on from such naming and shaming. I think the Women, Peace and Security agenda, I mean, obviously it's very complex, it's very detailed in many ways, it's very technical in many ways. There's a lot of responses around technical responses to various aspects of it. But I think there's sort of a few clear messages that come out of it. I've already emphasised the linkage between gender-based violence to women, in particular, in armed conflict and the maintenance of international peace and security. I mean, that's the framing point for the Security Council. But from that sexual violence, when used or commissioned as a tactic of war in order to deliberately target civilians, this is a quote from resolution in 1820, as part of a widespread or systematic attack against civilian populations, can significantly exacerbate situations of armed conflict. Therefore, prevention and dealing with such issues are an important way of trying to minimise the harms of armed conflict in general. I think there's a sort of somewhat mixed message throughout these resolutions between presenting women as victims and passive in need of protection, and also emphasising issues relating to women's empowerment and participation, agency. The latest resolution, 2122 of 2013, emphasises strongly leadership roles and does actually acknowledge the Security Council's failure in really taking account of leadership roles and building on them and trying to foster them further. I think it's also interesting if you read the different language between the various legal aspects. The Security Council does not talk about human rights in any detail, for example. As I mentioned a moment ago, it talks about services to women, medical services, educational services, social services, as opposed to entitlement and rights as under the human rights framework. And I think that also plays into reparations, an idea of reparations being in some way a sort of an ex gratia payment from society, as opposed to the obligation under human rights law for victims of violations of human rights. So there's a sort of different language aspect. Okay, I should be finishing. So where does this take us in terms of the centre and generally? Clearly there's a large body of law. I don't think we need any more law, quite honestly. And the bigger issue is, on the one hand, enforcement and implementation of what we've got, and on the other hand, making these various bodies of law work together in a sort of coherent package that can be directed towards addressing the issues that arise out of sexual violence. I think also, and this is very much what was part of the proposal for setting up the centre came from essentially William Hague and the PSVI team. And I think a recognition that there's a lot we don't know. That there's a lot we think we know, but there's a lot that we actually don't know. And that policy in this area could be well informed by serious evidence-based academic research. I've emphasised the legal aspects, and that's because I'm a lawyer. But the centre is not going to be intended to be a legal place. I'll be working with colleagues who come from other disciplines within the LSE, in particular media, communications, gender studies, international relations, social policy, sociology, anthropology, etc. And that the need for multidisciplinary work, I think, is emphasised. I mean, just the sorts of areas that we might perhaps think about doing more research into. Patterns of sexual violence that I've referred to. Now, why does it take different patterns in different places? What is it that actually leads to the particular forms in different places? Why does sexual violence not occur in every form of armed conflict? What can we learn from looking at those places where there hasn't been a high incidence? Or are we in fact missing that there actually is, and we just believe there hasn't been in certain places? So, what is the story around places where it is not an evident and immediate part of the picture of the conflict? What does work to enhance accountability, and what doesn't work? What are the obstacles more generally to women's access to justice across a much broader spectrum than, again, just the issues relating to sexual violence and armed conflict? Reparations, I've mentioned a couple of times. Again, what should be the focus of reparations? What should they be directed at? How should they be implemented? what's the linkage between reparations, economic, social rights? Would greater participation by women actually make any difference? We all sort of aim at that as a sort of important point, but would it make a difference? How would it make a difference? In what ways? Why? And if so, if there are answers as to why it makes a difference, how can that be built upon to make that rather more effective? So I think the rationale behind establishing the centre is that the political and policy programmes for combating gender-based violence will benefit from focused academic research, that we will attempt to develop research and practice across the LSE, across the various disciplines, and I think most importantly to try to bring together, this is why a place like this is great, academics, practitioners, activists, military, those involved in conflict areas, those of course who've been victims of sexual violence, to try and build on the LSE's general tradition. Now sounded like a selling point for the LSE, but I'm sure there have to be some LSE alumni in the room. There always are. But the LSE does have a long tradition of socially oriented research that feeds into policy making and so on, and to try and build upon that expertise that it's got in those particular areas. So those are the aims that we've got. I suppose I ought to add that we are intending to introduce a teaching programme as well around these various issues, both at the master's level and possibly more at a sort of external training area. We're very much at the beginning. I feel utterly daunted when I even start thinking about what it is that we've got to do. So welcome any comments and discussion. Thank you.
Well, thank you very much. That was a very rich presentation. It's now time to open up to the floor for comments and questions. So whoever would like to say something, please raise your hand. And if you could also introduce yourself, it's for the benefit of the speaker.
My name is Karen Mann. I'm the policy manager at Women for Women International.
Oh, right. Yeah. So you know lots and lots about all of this, yes.
My question was around situating sexual violence and conflict within the wider spectrum of violence against women and girls more generally. For me, one of the key points of preventing sexual violence without relating to the initiative is around situating it within the wider spectrum of law, and around countering discriminatory social norms, and providing access to services for women, including justice and education and wider empowerment things. And I just wondered, from a legal point of view, with the focus on sexual violence and conflict, which is very much around combatant perpetrator sexual violence and other forms of violence, gender-based violence, do you think there's an opportunity to use the legal framework that exists around SVC for improving the legal framework around VAWG more generally?
Yes, is the short answer. Although I'd actually put it the other way around. We have the development of the human rights framework, which is essentially the way in, I think, to the various issues around prevention of sexual violence and responding to. Again, we ought to be drawing a link or a differentiation between sexual violence and gender-based violence. Gender-based violence being the broader concept, sexual violence being particularly targeted at sexual aspects. And I think this whole idea that somehow sexual violence and armed conflict is something different. And I think we have a real issue, say particularly in countries such as ourselves, of seeing sexual violence and armed conflict as a matter of foreign policy. It's William Hague was Foreign Secretary. We can see that in the sort of very growth of the initiative in this country. And not linking it to those norms that have already been developed. Now, implementation is still a major issue in human rights law, obviously. But nevertheless, there's been a lot that has been done through the European Court of Human Rights, through the CEDAW Committee, through all these various bodies in building up a clear set of what does constitute due diligence, what is required, and particularly the work that's going on at the moment in understanding how gender stereotypes feed into the incidence and normalisation of violence against women in non-conflict situations, which then clearly carries over in various ways in conflict. So I think all of that is part of the important framework that needs to be part of any PSBI sort of type framework. I mean, just to throw out as an example, why is the UK leading the PSBI aspect and as yet has not become a party to the Istanbul Convention? The Istanbul Convention is the convention about preventing and combating violence against women here, at home, with obligations. And I think that sort of joined up thinking, and if we could get it from government policymakers as well as below, is just absolutely vital. Which probably doesn't answer your question, but I mean, your short answer was yes, I do agree.
Okay, so the gentleman over there.
My name is Michael Manish. I'm a researcher and I deal with the Middle East. Actually, you did mention the states, the international communities such as the United Nations and the member states that are there. Actually, 3 years ago, I think, or 2 years ago, for example, the Iraqi government, based on they passed a law which is called the Jafari law, and that basically allowed for the marriage of 9-year-old children, absolutely kids, and that which violate any human rights.
Absolutely, all of them. Yeah.
And yet it was passed on without any involvement by the international community, such as the United Nations, such as the Special Committee on
Right to the Child.
And it was passed by. I'm in a way sort of like cynical. And you being a lawyer, and I did a couple of advocacy myself as well. Most of the Iraqi government officials actually have got second nationality. They're all European. They got European and British nationality. And it easily can be any of these organizations in here. They can take legal action against them for committing such crimes. I am cynical in the sense that all these international committees, all these human rights committees, seems to ignore that. There was another issue as well, which I was very, very passionate about. After 2003 invasion, there's been a lot of abduction of young girls and use for prostitution and slavery, and yet it passed on without anybody, apart from an article in Time magazine which highlighted the issue. And yet, there was nothing here ever said to the Iraqi governments that were coming, all these officials coming in and out. And I met William Hague as well, and I did mention that to him. But sadly, politics played part in pushing this on the side. While these individual human rights committees that we have here in the institution could have easily walked into the High Court and took legal action against these individuals, and perhaps caused a diplomatic incident. But what the hell? It highlighted the issues, and yet they didn't do anything of such. There is, I think you did mention, I do agree with you, the mechanism. There is no aggressive leadership in basically highlighting this issue, in the way that it should be.
That sounded more like a comment than a question. And look, I agree with you absolutely. And I think it links with what I said a moment ago, that there's a real issue around narrowing sexual violence in armed conflict as a foreign policy issue, divorced from its place in foreign policy more generally. I mean, you mentioned the Iraq invasion 2003. I mean, another area that I'm sort of familiar with the aftermath was the 1999 NATO action against Kosovo. And in both of those, I mean, they are presented as important foreign policy initiatives of the country. And so therefore to focus on the aftermath and the forms of sexual violence that occur in the aftermath detracts from the legitimacy of the invasion in the first place. As a foreign policy issue, we've got to say this was a good thing. And it's left to human rights lawyers, it's left to those who are dealing with the aftermath of what happens to individuals in these ways. I mean, another point that you've just raised, which is very, very clear and gets left out, I think, of the framework, is the linkage between conflict, post-conflict and trafficking. It is absolutely clear that in many situations of post-conflict, trafficking has increased in ways and in ways connected with the conflict exponentially. Just as very sort of simple examples, borders become extremely porous during conflicts. Transport of arms, transport of people, and so on. It all feeds into transport of people afterwards as forms of trafficking. And again, I think joined up thinking, and this is where I always feel a hopeless academic. What have we can criticise foreign policy people? Criticise academics for being essentially divorced from the real world and sort of looking at these issues as academic ones, not as problems that we can address. But part of the, if research can expose and make clear evidence base that these connections are there, hopefully they become harder to ignore. But political will, political imperative at the end of the day, still, as we know, too often pervades.
So we have 4 people line up.
Should we take them all?
Yes,
and then,
sure.
Hi, my name is Catherine Bell. I'm a military instructor for NATO militaries, African militaries. I can say on the one hand, on a positive note, having gone most recently to Uganda to provide training to potential peacekeepers, that this is the sort of thing that's included in the training. And seeing from African instructors themselves, they highlight that this is an important issue on the ground, if not for the moral aspects of it, certainly the practical side of it. On the other hand, there's...
Sorry, can I just ask a question? Is that training of state forces?
Yes.
Or, because again, that's another...
But it was a multinational environment, so it wasn't just the Ugandan force.
Sorry, I didn't mean to belittle it.
No, it's fine. And it's such a small event. Each one of these events only captures such a minute percentage of the potential peacekeepers out there. And it's, based on evidence today, there's still a long way to go. I mean, we look at Mali, and it's the very Malian army officers that are standing in the way of rape cases going to court. And so that obviously is the negative reality of it. But my question for you actually pertains to the recent, I think, encouraging development that women are now being, a certain quota of women is being requested by the UN. There's already a certain percentage of women that are part of these peacekeeping forces because of the better access they have to women who have experienced sexual violence. And the fact that that this is a tool used in, I think, just about every African peacekeeping operation that's out there. This is a positive development, but it's so recent. And so my question is, have you seen at this stage have we seen the intended effects of involving women military members or police within these peacekeeping operations? In the, 2 or 3 years maybe that this has been happening? Are we seeing the intended effects?
Not that I know of, is the short answer. That doesn't mean to say we're not. It's just that I don't know of any. It comes back to the need for research, and evidence-based research to find out just, is there a critical mass that's needed? So what is that critical mass, if that is the case? Do we need particular measures taken to assert their level of seniority, for example, within the peacekeeping forces? Do we need particular issues to ensure that there's a line of responsibility up to the top support? There's a whole load of questions about how that should be best optimally managed and so on. And those are precisely the sorts of things that, I'm not saying that we can go and do things like that, but research agendas should be looking at precisely those. What's the effect of all women peacekeeping forces, as we've had in some places? I mean, that's another very interesting. And I suppose there's also the question is, what is their effect on these particular offences, but how effective are they in the whole host of other activities? Is there an impact? Is there a differential, plus or minus, with respect? I mean, peacekeepers have very, very broad mandates these days. And how does it impact upon the whole lot, not just on this particular aspect?
Okay. Valentina?
Yes, thank you. Hi, my name is Valentina Borlacci. I'm working with a human rights NGO in Cameroon currently. I'll sit back down. First, I'd just like to commend all the men that are in the room today, because it's nice to see a room full of, half full of men on this topic. Secondly, you mentioned accountability as one of the 4 pillars, and the naming and shaming being important. And you also mentioned the fact that everyone from military official, militia to peacekeepers are involved as perpetrators. To what extent has there been research, or could there be research, either within NSC or other forums, to inform policy whereby there's a bit of naming and shaming of these government officials who are themselves perpetrators or perpetrators or people who facilitators of such types of sexual violence? Because to me, when I look at how long we as a society have been addressing this issue, and how, yes, there has been progress made, but not enough to really make a difference, I wonder why it is. And to me, yes, there is a great grassroots level discussion going on amongst all of us. But from the top down, that's really where it stops. And as I prepare to go to Cameroon in 2 weeks, I'm hoping to meet with, if I'm lucky, government officials, but to where to even begin to address their accountability is a difficult one. And so I wonder to what extent there has been some research, could be some research, and should be some research.
Certainly should be, certainly could be. I just, again, as an anecdotal type response to that, look what happens when the ICC indicts Bashir. He almost becomes a victim, and sort of object of, why is he being targeted, etc. And I can't remember his name. Likewise, the person from Kenya, which I think they've just dropped the charges, in fact, now. Sorry? Kenyatta, thank you. That sort of indicates, doesn't it, almost that we shouldn't be going. That there's an attitude that going to the top is in some sense unfair or politically motivated, or singling out particular leaders and not other leaders. So there's again a whole host of other questions around that. The person next to you from NATO, who just spoke a moment ago, you mentioned Mali. I was in Mali quite recently looking at, there's an EU training mission in Mali as well, looking at that and talking to the Minister of Justice in Mali. He was the one who was absolutely denying that there was any problem whatsoever, and that, yes, of course, there would be indictments and prosecutions, but, don't really have the possibility at this point, which again indicates both an unwillingness, even where not directly implicated, and issues around almost, I think, sort of the sovereignty of the country somehow when the leader is targeted in those ways. So, and again, I think we have an awful lot of this is about attitudinal change, isn't it? And about not accepting issues as normal, and sort of normalisation of violence. And that, I think, is really where the whole leadership aspect comes in.
If I could just chime in with an additional comment on that. It's interesting to see how a country like Liberia has managed to move on from its period of intense violence. It was the women actually coming together across a large region of West Africa and speaking out quite verbally that we women were the ones suffering, and we have taken charge now to fix the mess, essentially. And so now with a female president in Liberia, she has made it a focus of hers to look at the situation of women in Liberia. That seems to have been successful. I don't know if you would agree.
I'd agree, certainly at the moment. Who knows about sustainability and so on. But clearly has had, and again, an impact on changing attitudes. And the importance of responsibility at the top, sort of working there. And again, human rights rests upon the notion of state responsibility. And therefore, getting those at the top to accept that level of responsibility.
My name is Arif Abraham. I'm the legal officer at the Democratic Progress Institute. It's more of a comment, basically. So, my
this is a discussion.
Yes. So I'm working on an initiative to start of a small unit focusing on accountability for war crimes, especially in Syria. And the idea is that long term, there are essentially 4 broad mechanisms which can ensure accountability, international accountability. That's a referral to the ICC, a setting up a tribunal, both of which require UN Security Council approval.
Yeah.
Universal jurisdiction, so any perpetrators crossing borders on a third state prosecuting, or a domestic prosecution, usually by the victors of a war. So these are 4 broad long-term mechanisms. And my idea is to say, well, what can we do today in terms of legal accountability? And what I've done for Syria is to come up with a mechanism, and that's to basically say, well, currently you have people working in the field, either raising awareness of sexual violence or investigating generally war crimes. And the idea is that you can basically train these people up who are going out there to do interviews, collect medical evidence, etc., and to say, well, whatever you do collect, you can do so in a manner which is legally useful, i.e. you've got dates, names, places, possibly we can get names of people, we can find out locations where sexual violence has occurred in conflict, and then contemporaneously with that, analyse that, prepare case files, basically ready-to-go case files, effectively indictment-style documents. The idea for that is that if you have a whole lot of case files in a particular area, identifying perpetrators, you basically facilitate long-term accountability, because when these mechanisms come live, at some point they have to, in conflicts like Syria, that basically you've got this evidence that was gathered at the time that's reliable, and you can basically identify these people in the future. And so that's something that could be done right now across a range of conflicts.
And that's very much the thinking behind the international protocol that they launched at the Global Summit. That same sort of idea, the need to have evidence that, as you just said, that is usable and will be accepted as admissible in court cases.
The idea is that get this protocol, which is right now is great, it's an abstract, so it's great once people start using it. They've actually got somewhere to send this documentation, somebody who's then analysing it and preparing case files, because it might never get to the ICC, it might be a domestic tribunal, so somebody should have done this work before the victims and the perpetrators disappear.
And if we're talking domestic trials, we've got again the need to already start working with the legal profession, for example, so that they are able to carry such trials and the judiciary. The big fear, absolutely, I think all of that is absolutely needed and just needs to be repeated in all sort of conflict zones. The big fear always is, of course, that peace agreements may end up including amnesty provisions, which is certainly contrary to human rights law, but can become a negotiating tactic at different times, either explicitly or implicitly.
Okay. And finally, the lady over here.
My name is Hilary Stoffer. I'm a visiting fellow at the LSE. Sometimes I see Christine walk through the office. Not that often anymore. Just a very brief question. I was really interested to hear your passing reference to those conflicts where sexual violence is not a hallmark feature, which we never hear about. We only ever hear how terrible it is and of rape camps and everything. And I just wondered if you could very briefly expound on a couple of examples, just because I'm not familiar with these particularly.
Well, the most obvious one in terms of contemporary politics is Israel's actions in Gaza, where, you may know I was a part of one of the UN fact-finding missions in Gaza, and we had no evidence on any issues relating to sexual violence at all. And again, it's very interesting. Is it because it's a highly disciplined army in many ways, the IDF? I have no idea whether anybody else in the room knows anything about the military training that's given to the IDF, whether this is given a high priority or not. It may be the case. There were ground forces invasions and allegations of that as part of a fact-finding mission we found to be at least evidence, or prima facie evidence of, not at the criminal level of investigation, of other forms of abuses against civilians, but not sexual violence. I think that would be a very interesting one to investigate. Is it something we're missing? Or is that, really the case? In which case we could learn a lot. So,
well,
and Gaza this summer, the last one,
Okay, well, thank you very much. I think we're running out of time, and I know you need to be somewhere else. Well, thank you everyone for your contribution, and thank you, Professor Chinkin. Consider yourself invited to come and back maybe in a year's time or whenever it's convenient, because we would love to hear an update on the progress made by the Centre.
And equally, can I say I'd love to hear, people, sort of those ideas and programs that people are talking about would be great to be, in touch with and so on. We are hoping to make it as a sort of melting pot place. Yeah. So.
Excellent. Well, before we go, please join me in thanking Professor Chinkin.